Good morning. Thank you very much for taking the time to join me this morning. I want to begin by thanking Professor Besson for the invitation to join this very illustrious group of international legal scholars. So as you can see, the topic I want to discuss today is the contributions of consent to the legitimacy of international law. And I start with this kind of picture. International law, like all law, is a practice of reason-giving. It's one in which actors invoke legal norms to justify their conduct, typically to one another, but also oftentimes to themselves. Now, practitioners of international law generally treat those norms as providing sufficient reasons for whatever actions it is they want to take. And those actions may be their own conduct, or it may be criticism of others. But of course, we can also take a critical stance on that practice and ask ourselves, do these legal norms in fact provide good reasons for the actions that they sanction? And that's the question that I want to discuss with you today, right? So why treat the claim or fact, right? So if you're a legal positivist, why treat the fact that international law prohibits fying some kind of conduct as itself a reason not to fy? Right? Or in the language that I'm going to use today, what makes an international legal norm prohibiting fying legitimate, right? One that its addressees ought to obey. Now, on the one hand, you might say, well, that's just what it is to engage in the practice of international law. It just is to treat these norms as providing sufficient justifications for action. And I do think that there's some truth to that, but then we can reframe the question that is of interest to me, and that is, why should I play this game? Why should I participate in this practice of treating these norms as providing justification for action? Now, one common answer, especially in the Common Era, is that it is the consent of states, right, that explains the legitimacy of international law. That is, that explains why international legal norms provide sufficient justifications for actions. Indeed, some theorists go so far as to say that only state consent can play that role. But I think that's a mistake. So the first of the three theses that I'm going to defend today, or given the time constraints, maybe assert would be better than defend, is that, in fact, not only does consent not play the role of rendering international law legitimate, it's actually constitutively impossible for consent to play that role. I'll say more about that. Well, but then if not consent, what is it that accounts for the legitimacy of international law when international law is legitimate? And the answer that I will defend is that, well, international law is legitimate in those cases in which those it addresses will do better at acting on the reasons that apply to them if they defer to international law than if they act on their own judgment. I'll say more about that. Now, that doesn't mean that there's no role for consent. In fact, I think consent continues to play a very critical role in international law in generating legitimate law, right? But again, it does that work not by providing the justification for law's legitimacy, but rather as a means for crafting international law. State consent can be, I want to emphasize the possibility, not the necessity, can be a valuable tool for generating legal norms that satisfy that second condition. Now, one thing that may already be clear to you, but that I want to emphasize, is that I am a legal philosopher, and this talk is very much a talk in legal philosophy. Now, it is one that I think has implications for international law, but I'm very much on board with the vision that Professor Besson was elaborating this morning. So I come to you in the belief that some of what I have to say today will be of use to you if you are an international lawyer or international legal theorist, but also very much with an attitude of wanting to learn from you and learn in ways that might, in fact, kind of lead to modifications in the kind of account that I'm presenting here. But just to set the expectations accordingly, again, the focus here really is on very abstract questions of legal philosophy. And secondly, I do just want to acknowledge that most of the arguments I'm developing here today rest on the insights of the late legal philosopher Joseph Raz, who sadly passed away just last month. So to give credit where it is due, I do want to acknowledge Raz's deep influence on the arguments here. All right, so a few kind of normative and conceptual clarifications. First of all, what is consent? Well, I think the term consent, in fact, picks out two distinct but related concepts. The first is a normative concept. And here, when we're talking about consent, what we mean is a kind of normative power to alter another's normative position. Right, so if you think of all of us standing in various relations to one another, relations that are constituted by a set of norms, norms that establish various rights, duties, powers, and immunity, right? To talk about consent is to talk about a particular kind of power that we have. Again, it's a normative power, and it's a power to alter the norms that govern the relationships between us. So if I consent to your use of my pen to take notes on this scintillating lecture that I'm giving, then I have given you a right to do something which, absent my exercise of that normative power, you would not have. Right? Now, I think that is actually the primary meaning of consent. That is the kind of primary concept. But we do also have a second concept, which is in some sense broader but parasitic on the normative concept, and that is the descriptive concept of agreement. So if I say to you, I point a gun at you, and I say your money or your life, right? And you give me your money, I think there's a perfectly straightforward sense in which we can say that you have consented to new terms between us. You have consented to the transfer of your money to me. Right? There's no mystery here. And yet, I think there's also a perfectly straightforward sense in which we could say this was not, in fact, an instance of genuine consent, by which we mean it was not a successful exercise of the normative power, right, to alter the normative position or the normative relation between us. Both of these we're going to see play important roles in the legitimacy of international law. To consent is to do something. It is a performance, right? So again, consent is, in the primary normative sense, the exercise of a normative power. It is the doing of something. And so I think it's important to specify the conditions that need to be met for an act to qualify as consent, that is, to count as the exercise of this normative power. Right. And I think that there are, in fact, three conditions that need to be satisfied. Now, importantly, this could be an act or an omission, right? So, of course, we're all familiar with the possibility of consenting simply by not doing something, right? If you don't leave the room, then you consent to my use of your pen. I don't leave the room, I have consented. But I do so only if these conditions are met, right? Now, in fact, for the consent to be successful, right, in where it is not, say, in the case of your money or your life, these beliefs need to be correct. And here's one of many occasions where I'll throw something out, and if you want to talk about it later, I'll be happy to do so. The kinds of beliefs that these acts must be undertaken with are of two sorts. All right? They can be the intention, right? You can do an act with the intention of altering a normative, someone else's normative position. That would be a case of promising. But promises are a subset, right, a species of the genus of consent, because there's also cases in which you might undertake an action knowing that thereby you have consented to some change in another's normative position, knowing that you have thereby granted that person a right, say, but not undertaken that action for the purpose of granting that person that right, right? You might have some other reason for engaging in the conduct. What justifies consent? So the question here is not what are the conditions under which consent is successful, which might involve things like being voluntary or informed, but rather what is the justification for according to agents the power to alter another's normative position, right? And I think we can start by saying, well, we accord that power because we think it gives people control over some aspect of their life. Well, very good, but why is that valuable? And here I think we should acknowledge that there are a number of reasons why having that power could be valuable. Right. First are reasons of well-being, and in fact these come in two sorts. There are instrumental arguments. So if you think about consent as it arises in a kind of ordinary market transaction, right? I consent to a certain exchange with you of goods. This is an example in which consent is instrumentally valuable. It contributes instrumentally to the advancement of my well-being. In every case, no, of course not, right? But as a kind of general claim, I think it is borne out, and is borne out, as I say, because, again, speaking generally, right, people are especially well placed to discern what sort of changes in others' normative positions will advance their well-being. Right. Now, in some cases, consent may, in fact, be a constitutive element of a certain kind of relationship or accomplishment, which is itself intrinsically valuable. Right? So certain kinds of acts of consent that are constitutive of friendship or constitutive of a loving relationship, these are not means to some further end, but they are themselves constitutive elements of something which is intrinsically valuable, which is a component of a good life for human beings. So consent here also is valuable for the control it gives us because of how it enables us to realize some aspect of well-being. But in addition, it may be that the exercise of control over one's life is intrinsically valuable, entirely independent of whatever contributions it might make to well-being. So this is the idea, it's a familiar concept, whether you agree with it or not, that simply the exercise of autonomy, the exercise of choice or control over one's life is in itself valuable. The other key concept here, legitimacy, right, and just moving quickly here. Right. So I'm concerned with legitimacy as a property of law. I don't want to claim that this is the kind of essential definition of legitimacy that would apply in every context in which we might use that term. But when it comes to law, I'm going to assert that what it means to say that law is legitimate, right, is to say that it constitutes a justifiable exercise of practical authority by one agent over another. Right, or in language that may be familiar to you, law is legitimate when it constitutes an exercise of rule or government by someone who has a moral right to rule, right, over someone who has a correlative duty to obey. Now, some theorists maintain that law necessarily claims legitimate authority, that this is in fact an essential element of law. Right. Now, of course, to say that law necessarily claims authority is not to say that its claims are always borne out, that it is in fact, that it does in fact enjoy legitimate authority. In all those cases, it claims it. But nevertheless, law, in virtue of being law, right, in virtue of being an exercise of practical authority, necessarily claims legitimate authority. I'll just note that if that's the case, there is a compelling argument for saying that legal positivism provides a correct account of the existence conditions for legal norms. All right, so just as in the case of consent, we start first by elaborating the concept, and then we ask ourselves, what could justify according actors this kind of moral power? So too, legitimate authority is a kind of moral power. It involves, right, the power to impose duties on others. What could ever justify according agents that power? And here I lean fully into Joseph Raz's legal philosophy, right, and adopt what he has labeled the service conception of legitimate authority. The basic idea here, right, is that someone enjoys a legitimate claim to authority over me, right, in those cases where I am more likely to act on the reasons I have to act on if I defer to that person's judgment of what reasons I should act on than if I act on my own. So that's the first condition. But there's an important caveat here, which is that in the kind of conduct that's at issue, it's more important that I act as I have most reason to act than that I act on my own judgment. Right? And as that caveat suggests, there may be cases in which that's not the case. That is, there may be cases in which it's more important that I act on my own judgment than that I get it right. And that is, in fact, one of the kind of three caveats I mentioned, or kind of three comments, I should say, that I mentioned in the paper. For reasons of time, I'm not going to discuss all three, but I do just want to dwell on the second here, sorry, on the third, right, which is that the very rationale for legitimate authority, the idea that it will enhance our conformity to the reasons we have to act on, also indicates the limits of claims to legitimate authority. And there are two. Right? So one is where, in the long run, I will actually do better at acting as I have most reason to act by developing my own faculty of judgment. So a nice example here, one I think we're all familiar with, is parenting. Right? So we know that the parent is not always going to be available to determine for the child what the child ought to do, what the child has most reason to do. And so it's critical that the parent help the child to develop his or her faculty of judgment, so that the child will be able to discern what they ought to do. Right? But of course, judgment is a practical skill. It's something that can only be developed via practice. And so what parents do, right, or the ideal parent does, is slowly as the child matures, grants the child more and more freedom to act on their own judgments, even in those cases where the parent knows, right, and the parent is right, that the child is going to make mistakes. But those mistakes, right, are the price we pay for, in the long run, having an agent, the child, matured into adult, right, who is able to act on the reasons they have to act on. Secondly, there are some cases in which you can only realize some value, right, a value which provides a reason for action if you choose it for yourself, right? So love, I think, is a really nice example here. I'm not talking about marriage. Those are two different things, right? But in order to genuinely love another and to realize the value that is constituted by a loving relationship, you have to choose it for yourself. Right? So that would be another case in which it is simply impossible to act on the reasons you have to act on by deferring to another's judgment. Okay. So with these background concepts in mind, we turn to the first substantive assertion, which is that consent is in fact incapable of providing a justification for law's legitimacy. It is incapable of explaining why I ought to treat a legal norm as a sufficient justification for action. Now notice these are principled objections. So much of the discussion, certainly in domestic context, but also in the international context, focuses on how the various conditions for genuine consent are not met. Right, so Professor Pellet mentioned some of these in his presentation, right, that weak states may be coerced, poor states may be uninformed, right, and these are reasons to be skeptical that the consent that was given expresses, in Professor Pellet's terminology, the state's will. I think there is some validity to these objections, but in fact, I want to say they're also moot from the standpoint of explaining legitimacy of international law, because I think there are reasons why consent could not justify law's legitimacy. Now, there are three that I mentioned, but I'm only going to speak briefly about the first. Right? And that's the claim that consent turns out to be superfluous. So start with a case in which one actor already claims legitimate authority over another. Right? So the claim is already made. The question is whether the claim is justified. Well, if the service conception of legitimate authority is satisfied, right, well, then the claim to authority is already justified, regardless of whether the subject has consented. Now, the subject might at that point consent, but that doesn't add anything. The consent is superfluous. If we ask ourselves, did you already have good reason to defer to the authority's judgment rather than act on your own? The answer is yes. And now you might want to say, well, what about a case in which, right, the actor does not yet recognize the other actor, right, as making a claim to authority? Right, so think of a case in which, say, a state submits a dispute to the ICJ. You might say prior to that taking place, the state would not recognize the ICJ as having a claim to authority, and the ICJ would not try to exercise authority. And doesn't that show that the act of consent actually does generate the justification for the ICJ's subsequent decision, provides the account of why the state that submitted the dispute to the ICJ now does have a duty to comply with the ICJ's judgment? But I think this, again, exhibits a confusion. Right? It does explain, right, why the ICJ now will, right, issue a ruling that purports to apply to that state. Right? But it doesn't yet tell us why the state ought to comply with that ruling. It said, yes, right, you agreed to submit your dispute to the ICJ. Yes, but why should I then defer, why should I actually obey the ICJ's judgment? And then famously, of course, we'll say something like, well, pacta sunt servanda, right? Agreements must be kept. But this just restates the question. Why must agreements be kept? And in particular, why must an agreement to defer to the authority of the ICJ be kept? And here I want to say, well, the answer is it ought to be kept if, right, by doing so, the state is more likely to act as it has most reason to act than if it acts on its own judgment. Now, we need to fill in the background reasons, right? How is it that conforming to the ICJ's judgment is going to make the state more likely to act as it has reason to act? Fair enough, right? But all the justificatory work is going to be done by the service conception of authority, not by consent. Again, I'm happy to talk about some of these, and I'll just note, consent is abdication. This is a theme I want to attribute to Professor Toms, but we'll see whether I'm justified in doing so. All right, so if not consent, right, then what does provide the justification for laws, international laws? Legitimacy, well, of course, the service conception is going to be my answer. And very briefly, there are various ways in which international law can enhance our conformity to the reasons that apply to us. So just as one example, the process of negotiating multilateral treaties can correct for ignorance and bias, generating more information for individual states than they could possibly attain on their own, information which they can then use to determine more accurately what it is they have most reason to do. Again, happy to say more about all of these rationales in a later discussion. But now we have a kind of question about how do we tie consent back in. And so this is kind of the framework I want to present, and then I'll give some examples. So we start with the question of institutional design. And we say, well, what we should do is we should try to design as legitimate an international legal order as we can attain. Right? As best we can, to get as close as we can to one in which international law makes claims to authority only in those cases where its claims to authority are in fact justifiable. Now, we're never going to get that perfectly, right? But that's kind of the ideal towards which we should strive. Right? Well, there are two mechanisms, or at least as I understand it, two mechanisms whereby international law involves claims to authority. Right, the first is customary international law, which I understand is the community of states collectively making claims to authority over its members individually. And then secondly, the practice of using treaties to create institutions imbued either with legislative authority or adjudicative authority, or sometimes both. And that means then the question of the role of state consent takes two specific forms. Right? First, what justification do we have for the persistent objector rule in customary international law? And secondly, what justification do we have for saying that states are normally bound to institutions that exercise legislative or adjudicative authority only if they consent to do so? I think the service conception gives us a framework for thinking through those questions. Right? Roughly, it says that consent as a means for crafting law is justifiable if one of two conditions are met. Either, right, it's a way of crafting international law that enhances legal authority's ability to satisfy the service conception, right, or it actually demarcates some of those limits on legitimate claims to practical authority that I was discussing just a few moments ago. So I think there are 5 different ways in which consent might kind of meet either one of these conditions, again, in which making law via consent might enhance international law's ability to satisfy the service conception of legitimate authority, or demarcate the limits to international laws or any law's claim to legitimate authority. I have about 5 minutes, would you say? Okay. All right, so we'll rush through a few of these. First, de facto legitimacy. Right. Now, de facto legitimacy is, of course, you probably know, but let me just dwell for a minute on the distinction. De facto legitimacy is the belief by an actor that the conditions for legitimacy are satisfied. Right. Now, of course, that belief might be mistaken. In fact, it might even be a belief that is premised on a misunderstanding of the conditions that actually justify law's claim to practical authority. But nevertheless, if law is going to contribute to the production of social order in the distinctive way that law purports to do so, right, it's going to need to be viewed as legitimate. Right? Now, I've eliminated a bunch of argument between premises 1 and 2, which I'll be happy to fill in later. But the importance of de facto legitimacy, of making law effective at contributing to social order in the way that law does so, gives us a very weighty reason, not always a decisive reason, but a very weighty reason, right, in favor of treating international legal actors as subject to those norms only that they have consented to or to which they have not persistently objected. Why? Well, to do the opposite, right, to impose claims of authority on states without their consent runs a bunch of risks to the legitimacy, the de facto legitimacy, the belief in the legitimacy of international law. Now, of course, that might be a kind of loss of trust, right, or belief in the de facto legitimacy of just the norm that has been imposed without consent. But it's possible, of course, for that to spiral into something much larger, right? Either a loss of trust in other members of the international legal community. It could be a loss of faith in the entire project of international law as either an effort to achieve some kind of at least thin conception of global justice, or if not that, at least some system of mutual advantage. Now, of course, some international legal actors may already have lost that trust in other members of the community, that faith in the project already. Where that's the case, the imposition of a legal norm absent consent, right, might further deepen that loss of trust and faith, that is, right, reinforce existing cynicism and skepticism. And in some cases, it might even generate certain kinds of actions, right, by actors, right, having lost their faith in the legitimacy of the international order, right, actions which are both themselves unjust and further weaken international law's de facto legitimacy. So these considerations about the link between consent and de facto legitimacy, again, I think what Professor Pellet was talking about when he mentioned how consent contributes to the effectiveness of international law, right, I think give rise to a kind of pragmatic constraint on international legal authority. Right? It's pragmatic in the kind of practical reason sense, since we'll be introducing a different notion of pragmatism later today, which is a kind of concession to failings on the part of certain actors. Right? So even if a certain legal norm would satisfy the service conception, right, the fact that actors will view it as illegitimate is a reason to, right, again, a weighty reason to refrain from advancing that claim to international legal authority. All right, let me talk very briefly. So some theorists argue that there's something especially important or maybe even uniquely valuable about the consent of democratic states to international legal norms. Right? Let me take the especially valuable claim. On the one hand, domestic democratic procedures do a service in the form of correcting, or at least they can correct for biases and for ignorance. And so to the extent that kind of in familiar ways, domestic democratic politics can subject claims to more careful criticism, can serve as vehicles for the introduction of more points of view, there's reason to think that the consent of democratic states, right, is more likely to generate international legal norms that do, in fact, satisfy the service conception of legitimate authority. But of course, there are also vices of domestic democratic politics. So most importantly here is that they give very little say to the viewpoints of people outside that particular democratic state, who have generally no formal say in what the law or policy of the democratic state will be, and often very limited opportunities to participate in that public discourse. Right, thank you. So I don't think we should, so I think while we should value democratic state consent, I don't think we should kind of exaggerate its importance from the kind of instrumental standpoint of generating legitimate law. Right? And of course, we also need to take into account that unfair bargaining situations, unequal bargaining situations between states in contemporary international law can lead to democratic states, right, opting for kind of terms of interaction that they would not or not be able to attain if we had a more level playing field in international negotiations. Right. Because of those vices of domestic democratic practices, I kind of want to just throw out a possibility here. It might be worth discussing. Right, so the claim that no state should be subject to international legal authority without its consent is advanced as kind of especially true in the case of democratic states. And again, I think there's some reason for that. But I'm wondering about a case in which many democratic states have in fact consented to a given exercise of international legal authority, but there's a particular democratic state that does not. Right. I wonder whether we might have reason, especially if we think that state's reason for not consenting is attributable to these kind of vices, and the kind of limitations on current domestic democratic politics. Whether we might have reason, all else equal, to say, despite your lack of consent, this norm still does apply in your case. Now again, we might have reasons of de facto legitimacy not to do so, but if we set those aside momentarily, right, I'm wondering whether that kind of argument of no democratic state ever bound by a norm it did not consent to might be weakened just slightly. So let me just conclude with one last. So here's a question, at least of interest, I think, to certain political and legal philosophers, and that is, well, might the intrinsic value of political self-determination provide a justification for states not being bound by international law, subject to an international legal authority, even in those cases, at least in some range of cases, where they might do better by deferring to the international legal authority than acting on their own judgment? How much should we value political self-determination? So John Tassioulis has suggested, I want to be fair to John here, with many qualifications, but nevertheless has suggested that there might be cases vis-a-vis certain human rights norms, in which, in fact, it's more important that states be free to act on their own judgment of what compliance with those norms requires than that they should get it right. And I just want to throw down a gauntlet. I can argue for it later and say I'm not convinced. It's hard for me to see, especially if we imagine the perspective of the people whose rights are at stake, why we should ever value more highly the political self-determination of a state to determine for itself what justice requires than actually treating people justly. As I said, there's many more arguments. Well, in some cases there are arguments, in others all I have is the assertion. But I'll be happy to talk more about all of these later. Thank you very much for your attention.